Good morning, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national preliminary notice service. Today, we have a fabulous webinar conducted by Alex Barthett on the topic, Pay When Paid Sucks. So do this to get paid anyways. So without further ado, I'd like to introduce Alex Barthett.
Thanks, Ariella. My name is Alex Barthett. I'm a board-certified construction lawyer here in South Florida, and today we're going to walk through the steps of how to deal with pay when paid provisions and what you can do to make them unenforceable and get paid if you want to do that, or if you're a GC and you want to try to keep them enforceable, how do you do that as well? So let's get started. So on today's agenda, we have, I'll start with describing what is a pay when paid provision. What's the magic language that makes a pay when paid provision enforceable? We'll look at two provisions and I'll show you the difference. As a general contractor, what should you do to deal with pay when paid provisions? The subcontractor, how do you deal with them? Then we'll go briefly over your lien and bond rights because they are critical to understand and how they are impacted by pay when paid provisions. And if you have any questions, you can go ahead and submit them and we'll answer them all at the end. With respect to questions, again, use the GoToWebinar chat box, which you should see on the right. As you submit your questions, we'll gather them up and answer them all at the end. Remember, please do not include any names of people or companies in your questions. So let's get started by having me explain to you what a pay when paid provision actually is. In short, it is a contract provision that shifts the risk of non-payment from one party to another in a contract. So for example, you may have a pay when paid provision in your subcontract, and what that does is it says, if I, the GC, am not paid by the owner, then I don't have to pay you, my subcontractor. It's most commonly found in subcontracts, but it can exist in other places. So sometimes we see it between a subcontractor and a subcontractor. So they would pass on the risk of non-payment. The subcontractor would pass the risk of non-payment on to his or her subcontractor if he or she isn't paid by the general contractor. It's a legal defense to payment, and in Florida, it's valid and enforceable, meaning if you have a valid and enforceable pay when paid provision, and that is why you're not getting paid, then the other party is not in breach of contract for not paying you. And as I said, we see this, this provision frequently. I would tell you, in most every contract that comes across my desk, there are pay when paid provisions in it. So you need to be aware of what it looks like and how to deal with them. So let's talk about exactly that. What does a pay when paid provision look like and how does it work? In short, you need to have certain magic language in this provision to make it enforceable. There was a Supreme Court case about 40 years ago, and they defined the issue very clearly, and they said, if you use the words condition precedent or contingent upon in the description of your pay when paid obligation, then we're going to find as a court that it's valid and enforceable. So let's take a look at one provision. Under no circumstances shall the contractor be obligated to pay the subcontractor until funds have been advanced by the owner. Now, as a layman, as a non-lawyer, you would look at that and think that is a valid pay when paid provision, but in fact, it is not because it doesn't have the magic language. So let's take a look at another provision. Final payment shall be made within 30 days of completion of the construction project, acceptance by the owner, and as a condition precedent, receipt of final payment from the owner. So notice how it has the magic language. So first provision, no good, not an enforceable pay when paid provision. Second provision is an enforceable pay when paid provision. So just the inclusion of that magic language makes all the difference in the world from to make a provision enforceable or unenforceable. So let's get to the crux of the issue. As a general contractor, what should you do? How do you deal with these issues? So the first thing you should do as a general contractor is recognize that you need to have this magic language in your contract. So you need to have a pay when paid provision in your contract, or you should have a pay when paid provision in your contract, and it needs to have the magic language, condition precedent or contingent upon. That language needs to be in the pay when paid provision. Now, the example I showed you is a final payment provision, but you can have it in your progress payment provisions as well. So you want it in all the sections that have an obligation or describe your obligation to pay. That obligation needs to be contingent upon the owner paying you as a GC. If that magic language is missing, remember that provision may not be found enforceable. So you may have to pay even if you haven't been paid. Now, if you're a contractor general contractor that issues bonds because maybe you do public work or you do private work that needs payment bonds, you need to understand that your payment bond, in almost every instance, there are certain limited exceptions, but almost every instance, your bond is not subject to the pay when paid defense. Meaning, if you're a general contractor and you do, let's take an example, you're building a school, so that's a public job. Let's say it's a $10 million job. You have your subcontractor sign a pay when paid provision in your contract. It has the magic language, but because you've issued a payment bond, that subcontractor can sue your surety, and your surety is not able to assert the pay when paid defense. So remember that if you issue payment bonds on projects, your payment bond surety is not able to assert the pay when paid defense in almost every instance. Again, there are certain limited exceptions, but they are very rare. The other thing you have to be careful with if you're a general contractor is what your contract looks like with respect to final payment between you and the owner. If you, in your contract with the owner, agree that at the final payment of the job, that you're going to show the owner that you've paid all your bills before the owner has to pay you, that provision in the prime contract can invalidate your pay when paid provision in your subcontract. So that provision, the pay all your bills before you get your final payment, is a pretty common provision that most owners want. Most owners are okay paying trailing payments, usually 30 days behind, right? So they get releases, conditional releases for this month, unconditional releases for the prior month, but then the owner wants to true it all up. So when the owner issues the final payment, that final payment is not contingent on the contractor paying their bills, because the contractor has to get unconditional releases to get the final payment. For example, that a provision like that exists in the standard AIA prime contracts. So most owners are going to expect that. If that exists in your general contractor agreement, then when that's incorporated into the subcontract, which most prime contracts are, it now creates a problem, right? The owner's not going to pay the contractor until the contractor pays the sub. The contractor doesn't have to pay the sub until he's been paid by the owner. So you have this problem, right? Who's going to pay first? And the courts have dealt with this, and their decision is when we have this push because of these conflicting provisions between the prime contract and the subcontractor wins. So what you need to do as a GC is, if you are going to have this final payment provision, you need to just keep it trailing, meaning you want to say as a GC, my final payment obligations to the owner do not require that I give you unconditional releases. I can still give you conditional releases, and then maybe in 7 days or 15 days later, I give you unconditional releases. So you don't have to advance that payment. So be aware of that provision in your prime contract as a general contractor. The other thing that you want to do as a general contractor, which is related to pay when paid, is to require that your subcontractors always keep working even if there's a dispute. So a provision that looks like that would say, subcontractors shall diligently proceed with the work during any dispute, even as it relates to payment or changes. The existence of a dispute shall not be grounds for any failure to perform by subcontractor. So what does this mean? This means that if I'm the GC and I haven't been paid by the owner, I want to make sure my subs keep working so I can keep moving the job forward. And one of the ways to do that is to have a provision like this in your contract with your subs, so that even if there's a dispute, they have to move forward with the dispute resolution process. They can't stop working. Again, this is a pretty common provision we see in most subcontracts generated by general contractors. So now let's take a look at the other side of the same coin, which is, as a sub, what can you do? So the first thing is to try to strike the provision or strike the magic language. Right now, you, as a sub, understand the significance of those words. So you want to try to strike the provision or the magic language. It may be difficult to do because most contractors understand the significance of the provision as a whole, for sure, and many understand the significance of the magic language that I've described to you. What else can you do? You can look at the prime contract, which is probably incorporated into your subcontract. I described a situation in which, when you get to final payment between the owner and the contractor, that if there's this provision that exists in the prime contract where the contractor has to pay all their bills before they can get the final payment, if you can get to the end of the job as a sub, you may be able to show that your pay when paid provision in your contract is unenforceable. So when you see that in your subcontract it references the prime contract being incorporated by reference, you need to make sure you get that document, because all of those terms and conditions, not just the one I'm talking to you about, but all of them, become part of your subcontract. So your subcontract may be 3, 5, 10, 50 pages, but if it incorporates the prime contract, then those 20, 30, 50, 200 pages of the prime contract all are part of your subcontract. You should look at all of them so you understand the risks associated with contracting with on this project. Finally, you want to make sure that you look to see that you protect your lien and bond rights. If you have lien rights on a project, those lien rights are not impacted by the pay when paid, meaning if the owner doesn't pay the contractor, you still have your lien rights. And as I described to you before, if the contractor posted a payment bond on this job, you probably still have rights against that payment bond, even if you have a pay when paid provision in your subcontract. The other thing that you want to try to do as a subcontractor is to make sure you have the affirmative right to stop working if you are not getting paid. It doesn't invalidate the pay when paid provision, meaning they may not have to pay you, but at least you want to be able to have the unabridged right to stop working. So here's a sample sentence that would give you that right if you could incorporate it into your subcontract. Subcontractor can slow or stop work without liability or penalty if it has not been paid its draw request in 30 days after submission. There's lots of ways to tweak this provision. Maybe 30 days goes to 45. Maybe it goes to 60. But having the right to stop work if you're not getting paid is an important right that you should have in all of your contracts as a sub, because you want to make sure that if you're not getting paid, you can pull your folks off the job. You don't have to keep paying labor. You don't have to keep delivering materials, because that has the potential of effectively bleeding you dry on a job. So let's talk about your lien and bond rights so everyone understands who has lien and bond rights and how to protect them. So laborers, that's John Smith the carpenter, he has lien rights. Architects, engineers, and land surveyors have lien rights. Contractors, that's anyone in privity, direct contract with the owner, has lien rights. Subcontractors, subcontractors, and material suppliers or rental companies that have a contract with the owner, the contractor, the subcontractor, or the subcontractor. So the furthest rung under Florida law for lien rights are material suppliers and rental companies to subcontractors. Anyone below them on the totem pole no longer has lien rights. So the two that we see a lot that may try to have lien rights, but in fact they don't, are material suppliers to material suppliers. So if you're a material supplier and you provide materials to another material supplier who then supplies it to the job, you don't have lien rights. If you are a subcontractor or below, you don't have lien rights. So you need to know where you are on the pecking order here to know whether or not you have lien rights, because securing your lien and bond rights are critical at improving the likelihood that you're going to get paid on a job. So let's run through briefly the steps that you need to follow in order to secure your lien and bond rights. So within 45 days, no later than 45 days from your first work on the job, you need to serve a notice to owner for lien rights and a notice to contractor for bond rights. Remember, 45 days is the day that the owner or the surety has to actually receive it. So you need to do it well before that. I know Ariella preaches, as do we, the idea that you should have a process in your office to serve notice to owners at the time or right at about the time you sign the contract. Not before, but as you open up your job, because now you're doing a new job, part of that process should be sending the information to SunRay so that they can do your notice to owner right away. Always want to do it early in the 45 days. If you have a direct contract with the owner, if you have lien rights, you don't need to serve a notice to owner, but I still recommend that you do, because sending that document creates the impression with the owner that you're serious about getting paid. So I recommend that irrespective of where you fall in the chain, even if you don't have to serve a notice to owner, you should still do it. For bonds, meaning if you're a sub with a contract with the bonded contractor, you also don't need to send that notice to contractor. I still think you should, but it's not required in order to preserve your lien or bond rights. Step 2, within 90 days of your last work, you need to record your lien for lien rights or serve your notice of non-payment, remembering that the lien has to be recorded by the 90th day, and the contractor and the surety need to actually receive your notice of non-payment by the 90th day. Again, I strongly recommend that at about day 60 from your last work, that's when you're starting the conversation in your office about, okay, are we going to lien this job, or are we going to serve our notice of non-payment? Don't wait till the 80th day, the 85th day. You know, you remove all margin of error for things to get lost in the mail, you know, for the clerk to lose the document if you have to send it to them. For recording, don't take those chances. Do it earlier rather than later. Remember that last work does not include punch list or warranty work. So it's got to be before that. So if you show up on the job and you're the painter and you just do some touch-up, that's not your last work. It'll be when you actually had a substantial crew there doing work that would entitle you to get paid. And remember, 90 days is not 3 months. Some months have more than 30 days. Some months have fewer than 30 days. So if you're counting June 7th, July 7th, that's a mistake. You're gonna miss your days. We've created a tool to help you calculate these days. It's called the Calculene. It's an app you can download on your iPhone or your Android phone. If you shine your camera at those QR codes, it will take you right to the page. You can select whether or not you want to calculate the 45 days for a notice to owner or the 90 days for a lien or a bond, and it will calculate all the days, including weekends and holidays, so that you know exactly when your notice to owner is due or when your lien or bond rights are about to expire. So almost done here. Step 3, within 15 days of recording your lien, you need to serve it on all interested parties. If you use SunRay to do your liens, they take care of all of that. They'll serve they'll record the claim of lien, and they'll serve it on all interested parties. Step 4, for those that have a lien and those that are in direct contract with the owner, you need to serve what's called a contractor's final affidavit. This has to be done no later than 5 days before you file a lawsuit to foreclose on your lien. And my advice is, if you know you have to do this, you do it at the time that you do your lien. So if you're going to have to do a lien and you are in direct contract with the owner, then you would go ahead and prepare and serve a contractor's final affidavit at the same time. Step 5, for liens, you need to file your lawsuit to foreclose on the lien no later than 1 year from the recording date of the lien. This is the outside deadline. You can do it sooner than that. You can record your lien while you're still on the job, and you can file suit on your lien while you're still working on the job. All of the dates that I've given you are the outermost dates that after those dates, you will lose your rights. You can always do it sooner with respect to recording your lien and filing your lawsuit. For bonds, you need to file the lawsuit against the bonding company and the contractor no later than 1 year from your last work. So notice the difference between liens and bonds. They're not the same time to file the lawsuit. But again, I would advise you should not be waiting that long anyways. Within 60 to 90 days after you record your lien, if you still haven't been paid or served a notice of non-payment, if you still haven't been paid, that's when you need to actively be thinking about retaining a board-certified construction lawyer to help you collect, because just letting it sit after you've tried to collect on your own is not likely going to get you paid, and waiting is not a good idea. Exceptions apply to every one of the rules I told you. So the lien law is very complicated. You always have to remember that every one of the rules that I've told you has exceptions to them. So if you have any questions, you can send me an email about them, or you can go ahead and submit your questions now in the chat box. Ariella, are there any questions so far?
There are 0 questions so far, but if anyone would like, as Alex just stated, to send us an email, we would be happy to answer any of your questions. So if you want to go to the next.
Yep, two last things. We have a podcast that we put out every week. So if you're a podcast person, we have it on iTunes, Google Play, Stitcher, or wherever you get your podcasts. And we have a short podcast every week on different topics related to contracts, liens, bonds, collections for construction. They're usually very short. Most of them are less than 6 minutes long, so that you can find them useful to you, I'm sure. Finally, we have 2 other upcoming events. We have a live event in Boca Raton on October 16th from 8 to 11. It is a deep dive on how to get paid with liens, bonds, and contracts. We'll go into a great level of detail on contract provisions, the rules and exceptions to lien and bond claims. We do these webinars for free every month. The next one is September 20th from 9 to 9:20, and the topic is 3 lien release tricks you need to know. So make sure you sign up for that. You can sign up for all the webinars and live events at sunraynotice.com/education. And with that, Ariella, unless someone has submitted a question.
We have one quick question.
All right, let's do it.
All right, good day. We are a subcontractor. We are about to close a deal, but the letter of intent. But in the letter of intent, they're stating the pay when paid. What should we do?
So letters of intent can be tricky. Some letters of intent are unenforceable, meaning they're just an agreement to agree, and courts will not find them to be an enforceable contract. some documents that are titled letter of intent have enough provisions in them to bind you and actually be a full-fledged contract. So without looking at the document directly, I can't tell you if it's one or the other. In my experience, most contractors give letters of intent that are typically binding contracts because they want to lock the sub down in their contract. If you agree in a letter of intent to certain terms and conditions, then those terms and conditions will follow you into a subsequent contract. So my advice would be, if you are going to review and execute a letter of intent, you need to be comfortable with the terms and conditions in it. So I would suggest that you employ some of the tactics that I've discussed in this webinar. So maybe try to strike the magic language, try to include a stop work provision. The other thing you need to be aware of is, in addition to some of the highlighted terms and conditions in the letter of intent, many contractors make specific reference that you will agree to sign their form of contract, and they may not have given that to you yet. So I would suggest that you take a look at that contract as well if it references such a term, because there's probably a lot of other nasty terms and conditions in that document. So yes, if you sign a letter of intent that has a pay when paid provision, you're probably going to have to live with it in the future. So you need to deal with it front and center in the letter of intent. Any other questions, Ariella?
The person expressed gratitude.
Good. If you have any other questions, send Ariella or me an email. You can also call us. Our contact information is on the screen. And I hope that many of you decide to join us at either the live seminar or on our continuing monthly webinars. Thank you very much.
Thank you, Alex. I hope everyone has a wonderful day.